So, good evening, everybody, and welcome to tonight's presentation. My name is Philip Gray, and I'm the current chairperson of the Engineers Ireland GB region. Before we start tonight's presentation, I'd just like to introduce you to the region. The GB region is a hub for members based in mainland UK. We represent all sectors of the industry and provide local CPD and networking events for our engineers. We arrange many presentations, normally some site visits during the year as well as panel talks and social events such as our annual pub quiz, our five-a-side events, and also our golf events, where all proceeds that are made from those events are donated to charity. If you aren't already following us on LinkedIn and want to find out more about our upcoming events, I would recommend following us on the Engineers Ireland GB region LinkedIn address. And you can also find out more about the region on the Engineers Ireland website and also through our email at gbengineersireland@gmail.com. So tonight's talk is by our very own Christopher Quebral, who is a committee member of the GB region. Christopher is a qualified engineer and is also a trainee solicitor. And as such, he's in a unique position to speak about tonight's topic on contract law. Throughout the presentation, could I ask you to use the Q&A forum on Zoom to ask any questions you have? And at the very end of the presentation, I'll ask these questions to Christopher. So I hope you enjoy tonight's event, and now I'll hand you over to Christopher. Thank you very much, Christopher.
Hey, good evening, everyone. Thank you all for attending this short course, an hour's course about contract law. So I am a trainee solicitor, so I need to mention that I am from DIA Solicitors, who are my supervising solicitors. Okay, so tonight I will be discussing a bit of contract law. Of course, I won't be able to discuss it in really depth, like in real detail because of the constraints. However, I hope that it will give you an insight on the basics of contract law. Okay, so let me start now. I'll start with the purpose of the presentation. So I prepared this presentation for small practicing firms and also for individual engineers providing services to clients, consulting engineers, and the like. The reason for that is most big companies have their own lawyers already that they could just go and ask any questions. However, in many circumstances, small practice engineering firms and single member consultants, the cost of going to a lawyer is quite high and commonly disproportionate to the cost of the project itself. Okay. The other thing is the other purpose is it is to provide information and some sort of a roadmap in order for us engineers to avoid potential problems, such as entering into contracts that and then for some reason there's an implied term that we don't know, then we become liable for it. We don't even know why we were liable. However, because it is every case is different. Every case is different. It is not designed to provide you with a legal advice. During the Q&A question, you could post a Q&A session. You could post questions if you wish, and then I will try to answer every one of them. There might be some delays depending on the amount of questions that I will get, but I should be able to answer all the questions that you will post. Okay, so on the board, sorry, not on the board, on the screen, it's a list of some potential issues faced by an engineer. Okay, so say to give an example, there are claims due to breach of an implied term in a contract. So an example of this is to provide information within a reasonable time. More often than not, engineers enter into an agreement, but they don't, especially the startup ones, they don't reduce the agreement into a contract, into writing, and as a result of that, there are terms that are missed, and also if ever they reduced it into a written contract, the problem is the implied term that is not written on the contract. So then a part of one of it is the provision of information within a reasonable time. So for example, it will be implied that by the 2015 Act, that we are to provide it in reasonable time if the contract doesn't state when the information will be delivered. So in a situation wherein a construction is ongoing and the construction becomes at halt, goes to a halt because they don't have information to build. So then what is your liability on that? There's a potential, it is a potential breach of a contract term. There are also situations wherein we use standard forms, because even lawyers use standard forms and we just modify them. The trouble is the use of a standard form without modifying it, such as, for example, there in JCT, the JCT contract, the term reasonable examination. That term, when the word reasonable itself will create a lot of problems if not properly defined, because obviously what is reasonable to someone may not be reasonable to another person, and it creates a ambiguity. Okay, this is much true with the ICE standard conditions. So there will be terms that you don't like in a standard form. So it is up to you then to remove that or to alter it in a way that you will be able to reflect the intention of the contract itself. Okay, so another part is the standard forms. The standard forms extending liability to engineers' reasonable skill and care. So what it is an example is the collateral warranty forms. Most of these standard forms included on the terms of it will be that the engineer needs to extend its liability to do everything it can so that the project itself, so that the project is fit for purpose. Now, the word fit for purpose, it extends the liability of an engineer beyond reasonable skill and care. So I'll discuss that more as we go along. But an example of that is collateral warranty. The other implication of that is if your liability is extended beyond reasonable skill and care, most insurance companies, like a professional indemnity insurance, they don't allow extension of that liability beyond reasonable skill and care. And as a result of that, if you're not allowed to extend your liability, it means you will be in breach of a contract, especially in a collateral warranty forms, collateral warranty. Okay, next, again, there are standard forms putting the duty to engineers for work done by others. So how do you counter the liability on that? How do you address it if you don't alter the form itself? Okay, so there are also liabilities arising out of a deemed partnership. So I'll discuss partnership as we go along the presentation, and how you become liable on some situations wherein you don't even know you entered into it. Okay, there are also situations wherein you give instructions to a builder in your capacity as an engineer, and then your instruction will actually incur cost implications. What happens then? Who's liable for that cost implication? So again, I'll discuss that towards the as I go through the presentation. And one last thing, Defective Premises Act 1972. So this act actually says that the engineers or architects will be liable for a defect in the premises further down the line during the occupation of whoever's occupying it after the design and construction has been built. So I'll discuss all of this as I go along. Now, these are just issues that are faced by engineer, but obviously there's more to the list. There's more to the list than what I've written, but we'll try to address it now. I think that in order to address these issues that we are facing as engineers, I think it will be good to have some sort of a knowledge on the basics of contract law. So that is why my next stage then is a review of the contract. I'm sure a lot of you knows about contract law already, so most likely this will be a review only. Okay. So in a contract, before somebody becomes contractually liable, there has to be a legally binding contract. Okay. Now, a legally binding contract has elements. One, it has to have an offer. The offer should have been accepted, and there has to be consideration. So I'll discuss I'll discuss this in the next slide. So what constitutes an offer? An offer is a definite promise to be bound by terms. The terms that I'm referring to here are the terms of your agreement, your verbal agreement. So say for example, I would like to sell you my car for £500, and then somebody and the other party then would say, okay, I will buy your car for £500. That would mean then that you enter into the offer is acceptable because it is a definite offer, and the offeror, the person who gives the offer, by way of his actions and the words used, creates a definite promise to be bound by the terms of the verbal agreement. This verbal agreement, when accepted, can be reduced into a written contract. Okay. So the next thing is invitation to. I'd like to discuss about invitation to treat. Invitation to treat is it is a by way of an example. The famous case on this is the Boots Chemist case. So what it is when somebody goes into a supermarket and there's an object that or a goods, anything that you wanted to buy, it has a label on it, and you pick that up, and you bring it to the counter. So that action that you've done, the market is not actually giving you, or the grocery store is not actually giving you an offer. Instead, it is asking you to offer them to buy that particular product. So that is what we call as an invitation to treat. So let me give you another example of the effect of an invitation to treat. So one of the case from long time ago is the Bramble Finch hens. There was it was illegal to sell that kind of a bird, that kind of bird, and the person tried to label it as Bramble Finch hens for sale, and then he placed the price. So he was prosecuted for it, but he got acquitted, and the reason for that is he wasn't actually giving an offer. Rather, he was asking for somebody to offer him to buy that that hen for a particular price. So that is an invitation to treat. Another example for that, an invitation to treat, is the tenders. So tenders. So the client then, when somebody puts in a tender to a client for a project, the client is actually the tender itself is an invitation to treat. So the client is, you are inviting the client to offer you to buy that tender or to accept that tender. So that is an invitation to treat. Okay. The other thing is a carefully worded quotation of fees. So for example, we wanted to offer somebody our services. So if you had said somebody to this particular person that, okay, I am prepared to do the design work for you for £1,000 plus VAT. So you actually said that in saying that, in using those words, I'm prepared to do the design for you. You are actually doing an invitation to trade. In effect, there's no sale yet, so it cannot be accepted yet. So what happens is, if the client purports to accept purports to offer you to allow you to do the design for £1,000, then it would mean that you can accept that offer. So the offer is actually done by the other party. Okay, so I hope I've explained it well. And you could, if there are any questions, just put them on the Q&A. There are also unilateral offers. Unilateral offers, these are there's no need to these are offers wherein there's no need for you to it doesn't need to be directly communicated to the hold on, let me just drink some water, just bear with me. Okay, so the unilateral offers, these are offers that are made to the public, so that the public then, when acting on that the condition of that unilateral offer, means that they have accepted it. So I'll discuss with you the effect of acceptance in a minute. So let's move on to the termination of the offer. So when an offer is made, an offer needs to be communicated. If it's not communicated, then there's nothing to accept. So for example, let me give an example. When somebody tries to tell you, can you design my 4-story building, and he's on the other side of a river, and you can't hear anything. He's just doing you feel like he's mumbling words. Then that would mean the offer is not capable of being accepted because you cannot hear it. So it needs to be communicated. Now, communication of the offer, as long as the offer has reached the offeree, then it means that it could be accepted. The offeree can accept it. There's also this thing called counter offer. So when somebody offers you to do something, and you instead says, can I do it for something else? Say for charity. Let's say, let me give you an example. Let's say I told you, would you buy my car for £1,000? And then you give me an answer to say, can I buy it for 500? So those words that you uttered, can you buy me for can you buy it for can I buy it for 500, is a counter offer. The effect of a counter offer is to terminate the original offer that was made, so you cannot accept it anymore. Okay. In terms of business, the normal business hours are very important, simply because when an offer is made during business hours, and the offeree has accepted it also within business hours, then you create a binding contract, assuming that there's consideration made. So the offer can be accepted. So an example of this is when somebody, let's say a client, let's say an offer was made via email or fax, and it reached your office by, say, 5 o'clock in the evening, and you advertise that your offices are open until 6 o'clock in the afternoon, then it will be deemed that it was communicated to you. The termination of the offer, the offer was that you have read the offer. In return, you could also accept the offer in the same way. I'll discuss the acceptance of the offer in the next slides. An offer could also be terminated by lapse of time. Again, the word reasonability comes into play. So an offer to, say, for example, somebody offered to sell you some goods, say fruits, for the likes of fruits. So the offer will only be good if the fruits are still edible. If, say, and then when somebody then, the offeree then comes in to say that, hey, look, I want to accept your offer, he can no longer, let's say 6 months down the line, he can no longer accept that offer because of lapse of time, because the goods can, say, for example, the goods can no longer be are no longer edible in the example of a fruit. There are others. There are more situations in this case, but it boils down to reasonability. Or sometimes lapse of time when the offerer says that this offer is only open up to a certain period of time, say for 5 days or 2 days or 3 days. Then when the time comes, it will then lapse, so the offer is no longer capable of being accepted. So just an overview: an offer has to be something definite that is capable of being accepted to an offering by an offeree. Okay, acceptance. The next element of a contract is acceptance. When somebody makes an offer, it has to be accepted to start an agreement. Now, acceptance needs to be communicated. It needs to reach the ears of the offeror, meaning either he should be able to read it, or he should somehow get the information that his offer was accepted. The business hours, again, an offer can be accepted, especially when it's business to business. An offer can be accepted during business hours. So in short terms, assuming that the consideration, the next item will be consideration, and assuming that consideration is will be given, acceptance, when there's an offer and acceptance, normally there is already a legally binding contract. There's a legally binding contract. But in saying that, there are other things that needs to be taken into account before you can say that. But in simple terms, when an offer is given and it is accepted, then it is there is a legally binding contract. Okay. Now, silence. An offer cannot be accepted by way of silence unless there is an implied, unless your implied action purports to say that you are actually accepting the offer. An example is say a truckload of timber was delivered to site, and then a docket was given to you, and you didn't say anything, and you made use of the timber, and then you looked at the docket. It says there that the price of this timber is so and so. Let's say 5,000 pounds. Then it would mean that you have actually accepted the offer, even if you were silent. But in most cases, acceptance of an offer has to be communicated. So silence, the action, on the earlier example, the action that you have done, even though you were silent, you did an action. But if you haven't done anything and you were only silent, then it will not be a qualified acceptance. So the contract cannot be formed in so doing. Now, the postal rule, it's quite an important doctrine. What it is it says that an offer has been accepted at the time that the acceptance has been posted. So meaning once an offer has been accepted, you cannot cancel it anymore, because it has already been accepted. But there are situations wherein the offer has been canceled, but then prior to that, a letter of acceptance has already been posted. So the postal rule will come into play. Now, there are in terms of the postal rule, there are things to take into consideration for it to be valid. One, it has to it has to be posted. It should have been the letter of acceptance must be posted during the giving a reasonable period of time for it to reach the recipient. Okay, so that's an overview of the postal rule. And also it has to be reasonable that you have accepted the offer by way of post. So there might have been it could be that it was an agreement that you could post it, then it would be an acceptable way of accepting the offer. Okay, next. The intention. There has to be another element is a intention to create legal relations. Okay, intention to create legal relations. In the commercial context, it's always presumed that an offer given by a company to another company, or to a company to an end user, there's a presumption that there's always an intention to create legal relationship. The only exemption there is the ex gratia payments. An example of an ex gratia payment is that okay, I'll give you a bonus of £500 for doing such a good job, and then the company says, no, I'm not going to pay you anymore the extra £500, and then you sue. So then the company could say that there wasn't any intention to create any legal relations, but it will be quite difficult to prove it, that there wasn't any intention to create legal relations in terms of a company and another company, or a company and an end user. However, in a domestic context, say for example, a father promises a son, say £20,000 if he stops smoking. So then, depending on how it was said, in domestic scenarios, it will most likely be deemed that there is no intention to create legal relations. Now, if there is no intention to create legal relation, of course, there is no legally binding contract, because you didn't intend to have an agreement that could be enforceable. Okay, so time is running fast, 30 minutes. Consideration. So in consideration, this is the last element of a contract, so that you can say that there is a legally binding contract. So by Pollock is a writer of a book. He defines it as an act or forbearance of one party, or the promise thereof is the price for which the promise of the other is bought. So what it is, it's just basically making a promise to the other that you will do something. So you're buying the offer by way of a promise, like a promise to pay or to do something, and in turn the other will also give you the whatever he asked you to offered you to do. So for example, if a party asks you to design a house, and then you say, okay, I will design your house for X amount, so they have an offer and acceptance, then the consideration factor comes in. The consideration then is either by way of a deposit, or by way of a promise for the offerer, a promise to pay for the work that has to be done, and the consultant engineer then to start working on investing his time to start working on the job. Now that would be a consideration. Okay, so it is a benefit to the other, but a detriment to the other party. On most occasions, benefit and detriment exist together, but there are some situations wherein only the benefit part comes in, which is also acceptable. Okay, so consideration does not need to be adequate. So an example of this is, say for example, I will design you gave £1 to design a 2-story dwelling as consideration. So you gave a deposit of £1. So the amount of time that you will be using to design a 2-story dwelling is worth more than £1. But it doesn't matter. It is already adequate, and it is also sufficient because there is value to the £1. So that would be a qualified consideration. Now, I placed in here a Chappell & Co. Limited versus Nestle Co. Limited. So in this case, the part of the consideration that was being asked is 3 wrappers of chocolate. So now the question arose whether those 3 wrappers of chocolate was adequate. Now, the law came in and says, I mean, the court decided that whoever's making the offer or the party can require what kind of consideration he seeks to have. So you can require, so the offeror can require what consideration he wants. So for example, a consideration, I'd like to have a deposit of £500. So that's a requirement of consideration, which if the other party pays, then that would be a benefit and detriment being present. Okay, so there are other items such as past consideration. Now, past consideration is invalid per se. An example of this is, say for example, you've already designed the building. So you've designed a building for your brother. Okay. Now, when you designed the building for your brother, you didn't have any agreement, and then your brother comes in to say that, okay, I'll pay you say £10,000 for designing my building, and then he didn't pay you. Now that cannot be qualified as consideration, and in effect there will be no binding contract. The reason for that is you have already done the design. You have already done the design, and therefore that consideration that you've done, wherein you've invested time to do the design, is no longer valid as consideration because it is past consideration. However, there are exemptions. So supposing the same scenario, your brother requested that you design the building, and it was your understanding that you will be paid. The only thing is he didn't mention the terms. He didn't mention how much you're going to be paid. And after you've made after you have designed, your brother then says, "Okay, I'll pay you £20,000." That your consideration then becomes valid and will form part as a of the element of the contract. So you will have the element of an offer, the element of acceptance where you embarked it, and the element of consideration will be present. So in effect, you've got a legally if the contract was started prior to you embarking the design, it would mean that it is you have a legally binding contract. Okay, that is what I meant in item number 3. So next, the existing duties. If there is a legal duty, let's say or a public duty, an example of this is, let's say for example, you were contracted to you entered into a contract for you to design a building or a house, and then while you're doing it, you were offered extra payment to use appropriate skill and care, and then further down the line you didn't get paid. Now, because you've got an existing public duty or legal duty to use appropriate skill and care in doing your design, then that extra money or extra payment is not enforceable. There's no contract. It is not a valid consideration. The next thing is in a contractual obligation. The same thing again. Let's say, for example, extra payment to design all the elements is required in a project. So you've done all the designs. You're doing all the design work, and then your boss or your employer tells you that, hey, look, I'll pay you extra to design all the elements. So in this case of Stilk and Merrick. So what happened in Stilk and Merrick was there were sailors contracted to move goods from one place to the other, and then one of them fell sick. So then the boss man said, okay, I'll pay you extra money, just bring the goods over to the other side, and then he didn't pay them. But because they have those sailors have an obligation a contractual obligation to move the goods from one side, from A to B, then there wasn't any good consideration, and as a result, there's no binding contract. Okay. Now I said contrast with Williams and Raffy Brothers. In Williams and Raffy Brothers, it's a different story. What happened there is there was so the main contractor contracted to took subcontractors to finish timber works, And then the subcontractor didn't have misestimated the contract, the size of the contract, and as a result, he was going financially in financial difficulty. So he was going to resign already and just take the bullet because of it. So and then the boss then said, okay, I'll pay you extra money if you continue with the job. So they went on, continued with the job, and then they didn't get paid. The trouble, but the boss realized before offering the money that if I'm gonna go out and look for someone else to continue this, it will cost me more. So I would rather continue with this group of subcontractors. So in effect, there's a benefit, financial benefit of the decision to give additional money or additional payment to the carpenters. So because there's a benefit, then it would be an exemption to the rule. It will become a valid consideration to that effect. Okay. Okay, there's another thing when you go beyond your duties. So when you are contracted to do something, I place an example there. So we said, supposing the employer said, I'm going to pay you extra money if you design if you do all the necessary designs, structural design for a building. And then when you went on to do all the design, you realized that a party wall notice is necessary. Say party walls, normally you would need them if, say for example, you were digging deeper than the foundation of the neighbor. One of those scenarios, you will need the party wall notice. So an engineer is allowed to draft the notice. So the engineer then drafts the notice. It means that he went the extra mile beyond the contract that he already signed for. Then the promise to pay him extra would become a good consideration. Okay. Now there's another thing called promissory estoppel. A promissory estoppel is an equitable doctrine. What it is you promise to waive a legal right. So supposing you are entitled by way of a contract to receive an amount of money. However, the other person cannot pay you the amount because of the prevailing circumstances. You could then waive your right to collect that money. You could give the conditions. Let's say, for example, let's say you're entitled to receive £1,000. The client couldn't pay it, and you said, okay, I'll just pay you. You could pay me £500 for it, and then that's it. Everything settled. So meaning you agreed that you've released the contract, the other party from his obligation to pay the full £1,000. Instead, you settled for £500. There are three conditions to be met, however, for promissory estoppel to come into play. One is there must be a promise to waive the legal right. So the offeror or the contracting party who offered it could waive his legal right. Okay, and then the promisee, then the other side, the other party, must then act upon that promise. So supposing that the £500 settlement money. So for example, okay, here's the £500. So the promisee has acted on it. Promisee has acted on it already. Now, promissory estoppel is only a shield. It is not a sword, meaning you cannot use it to sue somebody. So you could only stop somebody from suing you because of the promise that he has done. An example is, let me give you an example. Say, supposing that £500 example that I gave you earlier. Supposing you said that after the promise he had paid you the £500, you then go back to him, hey, look, you still owe me another £500. So then the promisee then could say that, hey, look, I'm exercising promissory estoppel, meaning you cannot ask me to pay the extra £500 because you already waived that legal right. Okay, but he cannot use it to the promisee cannot use it as a sword, meaning he cannot go after the the whoever waived the legal right to do something. Okay, so it is an equitable doctrine, meaning if it's an equitable doctrine, there is it's consensus. So the question will be asked: it is right to allow any of the party to rely on the promissory estoppel that's there. So it boils down to reasonability. Okay. Next, the breach of contract issue. So then, knowing the basics of the contract law that we have already discussed, in order for you to refrain from breaching a contract, you need to ask. In order for you to determine whether there's a breach of contract, either on your part or the other contracting party's part, you need to ask whether is there an enforceable contract, meaning was there an offer that was accepted, and was there a valid consideration to that effect, and also what term has been breached. Which brings me to the contents of a contract. Okay, so the main contents of a contract are, but not limited to, of course, is the contracting parties. The question you need to ask is, are the contracting parties able to enter into a contract? So for example, 9-year-old kid, you enter into a contract with a 9-year-old kid. A 9-year-old kid cannot enter into a binding contract. There are of course situations wherein they can, when there's an adult acting in their behalf, but the 9-year-old kid themselves, because they're below 18 years of age, they cannot enter into a binding contract. So therefore, it cannot be whatever offer you entered into cannot be accepted. There's no valid contract. Okay, the next thing is the express terms. What are the express terms? The express terms, these are written on the face of the contract itself, so it will be very easy to spot. These are it tells you what are the terms of the contract that you are entering to. The most difficult part in a contract are the implied terms. These are the terms that you don't know. Sometimes most of us don't know that it exists. A lot of us knows, but most of us doesn't. They don't know that there's actually an implied term that is not. These are terms that are not written in the contract, and for all you know, you're already breaching it. And you'll be, if a problem comes in, you'll find yourself in breach of contract. Okay, so how are implied terms placed into the contract? So by actions of the court, So a contract could be supposing there was a problem and it eventually went to court. The court would then look at whether was it a custom? Is it a customary thing that you have been doing that it became the understanding of the other party that it is a part of the contract? If the answer is yes, then most likely it becomes an implied term. It is related to the previous course of dealings. So previous course of dealings, meaning you've been doing it for a long time, and that's always been the term of the contract. Then all of a sudden, you reduced it into writing. Supposing the original contracts that you had, it didn't have any. It was all verbal contracts, and then you decided to reduce it into contract. If the contract is then silent, if it's silent of the previous terms that you have been doing and it wasn't there, it wasn't written in the face of the contract, the court may be able to will be able to put an implied term to the effect of the previous dealings that you had. Another thing is the intention of the parties. So it may well be that there's a lot of situations wherein us engineers, we download the form, we sign it, we don't even look what's written on it. We just thought that it's okay. That's the standard form that we would normally use. So you never change it. You probably didn't we probably even didn't read it before signing it, and then the problem occurs, and then somebody says, "Hey, look, that wasn't my intention. The intention of this contract was to do something else. It's not what's on the face of the contract." So the court then will say, there's this thing called business efficacy test. So the business efficacy test is the court will ask the question whether if we implied this contract, will it make the whole business come into play? Will it achieve its purpose? If it is, then it should be implied into the contract. The officious bystander test. This is another thing, another test wherein if supposing two people were talking about an agreement and somebody was listening to it, what would he think? So if he asked the question, should it be should this term of the contract be included in your agreement? And if both people will say yes, it should be, but they never realized that in the first place until the officious bystander asked the question, then most likely it will be an implied term of the contract. Okay. Now also the type of contract and on the type of contract, the implied term will be dependent on the type of the contract. So is it the question there will again boil down to reasonability. The question is it reasonable to imply such a term? Most say for example, an example of this is supposing you're a tenant, a tenancy agreement, for example. Supposing you're a tenant, say it will be implied on a tenancy agreement that maintenance of premises that you are renting is included in the terms of the contract, even though it doesn't say it. It doesn't say it. However, there's a if it says that it explicitly says that maintenance is not included, then it is not going to be included. But if it's silent on the maintenance issue, it would mean that it could be implied because of the type of the contract. Okay, so there could be different types of contracts, and depending on the type of contract, we ask the question whether it's reasonable to imply such a term. The next, there are implied terms that are given by statute. So if it's an implied term, let's say the Sale of Goods Act 1979. The Sale of Goods Act 1979, it's not too much relevant to us as engineers because we provide services. These are relevant to people who are giving, who are providing goods. But what it is that the goods that you have delivered has to be, is like fit for purpose. The item that's really relevant to us is the CRA 2015, Consumer Rights Act 2015, specifically Section 49, 51, and 52. Now, 59 and 50. So Section 49 implies a term that services that will be that are carried out will be done with reasonable care and skill. So it is our obligation to provide such a in our the services that we provide that we employ reasonable care and skill. So Section 51 is relevant to a term called quantum merit. What it means is that if the contract you entered into does not specifically state the price, then the reasonable cost can be charged. So what is, let's say for example, this design of we design a say for example a steel beam. What is the reasonable price to design a steel beam? So that is what you are entitled for, and or the other. So it could be whoever asked you to design it. So like say the engineer is entitled for the say for example 100 pounds per beam in a domestic context. So the engineer is then entitled for 100 pounds, even though that it's not written in the contract, because it will be an implied term of the contract. Okay. The so sorry, that would be Section 51. I think I don't know whether I mentioned Section 52 or 51, but Section 51. Section 52 is about delivery, in-time delivery of of the services that we offered, that we are going to do. So this would be the drawings, the calculations, the reports that we do. We give them on time. So if there's no on the face of the agreement, let's say we said, let's say it's silent in relation to the delivery time, then we are there's an implied term of the agreement that you will deliver, that we will deliver the the services that we said we were going to deliver within a reasonable span of time. So now reasonability, again, this boils down to what is reasonable given the circumstances. It's a very long discussion and debate about reasonability, but there are rules about reasonability, which unfortunately is not a part of the. I couldn't cover it on this presentation. Okay, so those are the express terms. So we have the contracting parties, the express terms, the implied terms, and now we go to the exemption and limitation clauses. So under the exemption and the limitation clauses, normally there is a on a contract there's an exemption, and within the clauses of the standard contract there will be limitations such as it limits the liability of X party to the amount of, say, £200. This is especially so in the bill of lading. The bill of lading for when you ship cargoes, there are limitation clauses such as those. It's also present on the standard clauses, the standard contracts that we use in the field of engineering and construction. Okay, so so the basic rule is when you sign a contract, when you sign a contract, you agree that the terms of the contract are correct. That is the presumption. However, you could rebut that. You could rebut the presumption. So to rebut the presumption, I think I have it on the other slides. Let me see. During the interpretation of terms. Okay, to rebut the presumption, you have to have some evidence to show that there was a mistake. There was a mistake on the document that you have signed. So, and also that part of the standard term of the contract, for it to become binding, it has to be legible. It may be very small, but it has to be readable and understandable. It will also be enforceable. An exemption will also be enforceable if the it will be enforceable if everybody agrees to it. But the problem is if there is ambiguity on the exemption and on the clauses, meaning it has either two meanings or two or more meanings, or perhaps the terms that are being used cannot be understood, or there's a different meaning to you could put a different meaning to the terms that are being used, especially in the field of construction. Like a joist could be a ceiling joist, it could be a floor joist, it could be flat roof joist, but what exactly do you mean? So in doing that, in so doing, I think I'll move on to the next slide, which is the interpretation of the terms in a contract. So in there are some rules in interpreting the words in a contract. The first one is you need to give the ordinary meaning of the word. However, there are some, because if the ordinary meaning will not allow the contract to do what it has been written for. So the purpose of the contract, for example, so you made use of words, and in so doing, when you read it, it doesn't actually allow you to do the object of the contract. Then you go on to provide evidence to show what the meaning of those words are. So even if you have signed it already, there are some provisions wherein there was a mistake in the contract. Then therefore, especially when it's a standard contract, there are some avenues when it could be corrected. So special meaning of words may be taken as cannot be taken. Sometimes the words, there are special meanings on it, and if we provide some evidence to show that what is the meaning that we wanted to portray on that particular word, then it could be that could be changed. Okay, so there are maxims of interpretation. Maxims meaning these are the some sort of a guidance used by the courts in interpreting a contract. So that is not reasonable. That should read as reasonable meaning. Reasonable meaning. So as I've said earlier, the reasonable meaning is, so if you were, say for example, in a term of a contract, you were discussing the term of the contract is to change the flat roof joist, and then you were then referring to floor joists. So then the purpose of the contract is to change the flat roof joist, but the written word on the face of the contract are floor joist. One, it doesn't give you the reasonable meaning because you are dealing with the roof. So therefore, you are to interpret that as a flat roof joist rather than floor joist. You could also correct an obvious error, because it's obviously an error that you are dealing with a floor joist, whereas the contract says that you are going to do a replacement of or building of a flat roof joist, for example. Okay. So if you still couldn't determine the meaning of such a sentence or such a word, then you then go to the surrounding words within that contract. Are there mention of the same things that may lead to give you the meaning of that particular word or sentence? And then here comes other associated words in the entire document, such as, say for example, to build you're talking about structural design, and then the written word on the contract are all terms of architecture. There's a written word in the contract that says architectural design. Obviously there's a mistake, but then surrounding that document, they're talking about beams, foundations, some other things, concrete and all that. So those particular words all pertain to structural design work and not architectural. So that could be interpreted, that particular architectural word can then be interpreted as if it was a structural, something related to structural. Okay, so there's this word use them generis rule. So what it is if the sentence talks about say for example you're talking about brass, zinc, steel, and others. So the "and others" part of the sentence is supposed to create ambiguity. It opens a debate as to what others mean. However, based on the maxims of interpretation, you could make use of the words prior to it, such as the brass, the zinc, and other steels that are there, to mean that the "and others" part of the sentence actually means other kinds of metal because of the use them generis rule. So it's like a generic for all. It pertains to generic term for all metals. Okay. Now the other term is contra proferentum. So what contra proferentum is? Supposing somebody relies on an ambiguous term of the contract to his benefit, the interpretation of that particular term will go in favor of the one that is not relying on that particular term. Okay, so that's called contra proferendum. So if I am relying on a particular term and I actually drafted it and it's ambiguous, then it will be interpreted in favor of the other. Okay, so that's contra proferendum. I am running out of time, but I'll breeze through the points to note in contract drafting quickly. So okay, so the points to check in drafting of a contract. Firstly, you don't draft a contract unnecessarily because there are already standard contracts. What you do is to get that particular contract and edit it to suit your the purpose of the contract, using those basic rules of contract law, because it will always boil down to the basics. Okay, so what is the object of the document? So what's the purpose of it? What's the purpose of the document that you are trying to? So the question you ask is, does this contract allow me to do to serve its purpose? So for example, the contract talks about creating foundation, whereas my purpose is to build a roof, then obviously there's something wrong with it. You need to change it. Okay. Now, dependency on other documents. If a contract that you are drafting depends on other documents, then you need to say that say for example, Annex 1 or Schedule 1, Schedule 2, you need to say it on that particular contract. An example of this is the appointment contract, professional appointment contract. Normally, when you download a professional contract document, you've got the basic terms in front, and then you've got schedules at the back. But then when that schedule, when those schedules become loose or become dislodged, and you can't find it anymore, the contract itself becomes questionable. So you need to mention that there's a schedule referring to Schedule 1, Schedule 2, so and so, and you need to check what is the most appropriate form. So an example of this is, if you're entering into a collateral contract, don't be using an appointment agreement contract because it's wrong. So you look for the appropriate form. So I think that is I think that would be easy to understand. Now, the form of language. There are some contracts that requires very formal language, and there are also simple and direct language. The suggestion is that you make use of simple direct language because it is easier to understand rather than using formal. However, there are circumstances wherein formal language is unavoidable. These are languages we say whereas, or wherefore. All of those, when you start using those languages, you're now into the formal sense of it, and there's a different way of interpreting all of those. So you then ask, what are the necessary formal requirements? So let's say, for example, I'm going to go to the buying of a house. So what are the requirements in buying of a house? And what are those documents that I need to add onto the contract that I am drafting? Okay. One other important thing is the addition of these words for the avoidance of doubt. And then you start putting the implied terms that you think will be there already. So you look for it, and then you add it already into that contract, so that as the sentences for the avoidance of doubt. So you could add that into standard contracts, so as to serve that purpose. Okay. And the last thing is you need to be consistent. So don't be talking about floor joist on top and then talking about the foundations when what you really meant to do was to build a roof. Okay, it's consistency. Okay, and lastly, agency. There's a lot of situations wherein engineers make decisions under the rule of agency. Okay, and then they find themselves in a situation where they're being sued because there's actually no authority given on you. So the under the generic rule under agency is, one, do you have an express appointment, meaning a written appointment, and what are the extents of your agency? In the rule of agency, you are entering a contract on behalf of the client. It's not you entering into a contract. It will be the client. So anything that you do within that scope of agency is that the liable person will be the client. Okay. So there's also this, so it could be created through an express appointment, meaning written, and signed by you and the client. And there's also this apparent or ostensible authority. What is apparent or ostensible authority is a situation wherein you don't actually have authority to enter into a contract anymore, but then this was not communicated to the party that you wish to enter a contract with. But that party, third party, for example, thought that you are still an agent of the principal. So he thinks that you are still allowed to enter a contract. In that scenario, the principal will still become liable. But take note that obviously there's a tort of deceit. So meaning if you have done it on deceit, then you will be liable in tort. Okay. And the last thing, partnership. A lot of us enters into a partnership without us knowing it and entails liability. What is partnership? Okay, partnership is when two or more people embark into to do something for the benefit of money, for the benefit of money. So that's what happens. So an example of it is, say you've got your firm, you've got you've got your firm, you're running into you're running it to do consultancy work, structural design work, for example, and then the builder comes up to you and say, hey, look, can we do, let's do this, and let's do this job. You design it, I will build it, and we share the profit. So you now entered into, technically you've now entered into a partnership. The effect of that is your liability is not only on the design, you are also liable for the construction of it. So but you didn't even enter into a written agreement. You just thought that they just design it. The builder will say, just design it, and I will build it, and then we will slice the profit 50-50. So in effect, that you entered into a partnership. So take note, when you enter into these kinds of scenarios, especially unwritten ones, take note of the liability, especially so when you are a sole trader and you're not a limited liability company. The reason for that is a limited liability company is limited, the liability of it is limited, whereas an unlimited company, the liability goes to up to a personal level rather than just a company level. Meaning, if on a personal, like say for example, you as a person, not as a company, owns a beach somewhere in Asia, for example, that could be taken away from you because you were liable for something. Whereas if you were a limited liability company, it's only the assets of that company that will be taken into account when, say for example, a liability needs to be paid. Okay, so quantum merit, I've discussed that earlier, but what it is, it's the same as the provision of the CRA 2015, which says that if you have done X amount of work, then you are entitled to a reasonable pay. If it is not, if you did not agree to a fixed amount of fees. Okay, so going back to the potential issues faced by an engineer. So all of these things on the list could actually be addressed by our knowledge, our basic knowledge in contract law. We need, albeit that we need to do a bit more of reading so as to address the nitty-gritty part of it, but the basics of contract law will apply in order to avoid. If you apply them, you will the chances of you avoiding these problems will be better. Okay, so there are common contracts that we enter into, such as the professional appointments, novation contracts. Be careful with novation contracts, because the effect of novation contract is to cancel out the original contract. If you haven't been paid, for example, on that original contract, you probably won't be able to seek compensation on that anymore if you haven't been careful entering into a novation contract. Collateral warranties, again, it extends your liability. So when you sign collateral contracts, it is advisable to ask your insurance company whether they will extend the cover for liability, because as engineers, under normal circumstances, we are only liable to do our work with reasonable care and skill. Okay, so party wall agreements, it's the reason why I placed it on a closed open parenthesis is it's a different agreement that we engineers normally enter into on behalf of someone else, in behalf of neighboring in behalf of neighbors, actually. Okay, so I think it's still an agreement, and it's still subject to the rules of contract, albeit that there's some element to it that is provided by the Party Wall Act. Okay, that Party Wall Act is not a part of this presentation, and I don't think we have enough time to discuss more of it. So I will now go to my conclusion. The conclusion of it is good to use standard forms, but do not forget to alter as necessary to reflect intentions. Okay, it is good. The reason for that is the court will give meanings or will interpret the words of the standard contract based on the previous meanings that were already given to it. But the danger of it is if you do not edit it in such a way that it will reflect the intentions that you both parties wanted to achieve. Okay. Now, the last thing, be mindful of your actions, be mindful of our actions and the words that we say to clients, to builders, because it may constitute a warranty or may cause an implied term of a contract. You may be entering into another contract already. But again, go back to the whether you've done it or not, go back to the rules of the basic rules of contract and apply it and see whether you have if in the event that you have said something and the builder, for example, relied on it, whether you've got a binding contract or not. Okay, so I'm sorry for extending, but I think that brings me to the conclusion of this presentation. If you've got any questions, I'll be please feel free to post it and I will endeavor to answer all of it. Okay, thank you.
Thank you very much, Christopher. And indeed, we do have some questions after coming through. I don't know if you want to catch your breath there, maybe take a drink of water.
Yeah,
you've been speaking for a while now, so yeah,
it's a bit difficult to talk when you couldn't see anybody listening. You couldn't ask questions and things like that. Yeah.
So actually, the first question I have here from Paul, actually, you didn't actually touch on it in your last conclusion side there, but you can answer it again. So, are pro forma standard agreements, which are used in some industries, a good starting point to draw up a contract and a useful thing to read up on?
The answer is yes. The reason for that is as I've said, during the interpretation of that contract, the courts, for example, if it went to court, then they will give meaning as the meaning that they will take will be the meaning that was given to it already on previous occasions, unless of course external evidence is submitted that it is not the meaning that of the term that you wanted to put into that contract. So the answer is yes. So they like even lawyers, very, very seldom that we draft contracts from scratch. We always make use of pro formas, but we edit it.
Well, thank you very much. I hope that answers that question. And moving on to the next question, which is from Victor. And again, you gave lots of kind of good examples using just non-engineering examples throughout your presentation. And this is relating to purchase of a house. So if I were to make an offer to purchase an advertised house in Ireland, and if my offer is accepted from the seller, am I obliged to pay it? And a follow on from that is, I've been told by the real estate agent that sells it, that till I sign a contract, I'm not obliged.
Yes, that is right. That you enter into the area of conveyancing. The rules in conveyancing, yes, you are. It's a special type of a contract. So when you enter into rules of conveyancing, you enter into a situation where there are stages, and during those stages, there is not a legally contract done yet. But then you are purporting to enter into that contract, but not until the contracts have been signed or exchanged. Normally, you will exchange the contract on those scenarios. Then there is no legally binding contract yet. But there's a but on that. Supposing an offer was given to a buyer, right? Supposing an offer was given to a buyer, and the buyer then does everything they could so that he or she could buy that property, and then the seller would then say that he would not offer it to someone else, but then he starts offering it to other people. Okay, beyond your knowledge, the solicitor of the seller has the obligation to inform the solicitor of the buyer of such an occurrence so that they could address the issue. So it becomes a question of conduct of solicitors rather than a question of contract. But the short answer to that is there is no binding contract until it is signed, because the sale, the buy and sell of land requires a written contract.
Okay, actually,
Yeah.
just spotted a follow on. It was actually messaged in chats there from Mike. So in conveyancing, there are still formalities to observe before the contract is completed. I guess that's more a statement than a question, but would you agree with that?
Yes, it is. Yeah. So the formalities, say in conveyancing, there are searches. You need to do searches. You need to satisfy. There are forms as well. It's con 29. It's called 29. Con 29. Those are the forms that you need to fill up and to use. These forms are available in the Law Society website. And then those are standard forms. Again, because they're standard forms, you could edit them and make sure that whatever agreement you had during the negotiation process is actually on that on those documents.
Thank you very much, Christopher. And the final question is actually regarding CDM regulations. So this question is from Owen. So where do the CDM regs 2015 come into effect when a designer designs something that is not possible to build?
The CDM regulations, there's a condition for it to take effect. I think this will be a little bit of a extensive answer. I could, if you get the email address of the person asking the question, I could send the answer to them.
Yeah, we have the information there. So Owen, we'll
Yeah.
get back to you on that one. Thanks for the question. That is actually the last of all the questions, but there are some comments in there basically saying, thank you, Christopher, great presentation. I'd just like to echo that as well. So since there are no more questions, I'd just like to thank everybody for joining tonight's event. And obviously thank you, Christopher, for a great presentation. So on behalf of the GB region, I'm going to say good night to you all. I hope you have a lovely evening and hopefully see you at some future GB events soon. Okay, thank you very much. Good night.
Thank you. Good night.